Hello, everybody, and welcome to this month's meeting for the Amicable Divorce Amicable Divorce Network, and specifically, this is Amicable Academy, which is our education that we offer to the public. We have other types of meetings, some of which are members only, and those are called Amicable Hour. But in this particular series, we offer either public education, professional level training, and things of that nature that everybody's welcome to participate in. My name is Tracy Ann Moore Grant, and I am the founder of the Amicable Divorce Network. Our speaker today is Max Ruthenberg-Marshall, and she is going to be speaking today about flat fees, which I am particularly really interested in. I've picked her brain quite a bit. I know a lot of the people who are here today are family law practitioners who touch that area of law, and doing a flat fee for a family law case is probably something where you are very nervous about that because of the unknown. So what she is going to be speaking on is how to use the amicable process to introduce this to clients, to yourself and your practice, the pros and cons and benefits of this type of fee arrangement for those of us who need some more information. A little bit about the Amicable Divorce Network before we get started. As many of you know, we started in Georgia in 2019. We are now launching internationally. So we are accepting applications of members outside of the state of Georgia in all areas. We are launching a whole new website, a new look, lots of new marketing materials, education, things of that nature. And that should be completed within the next 30 days. So we do have an application process for our members. I'll be putting the application in the chat. If you are not a member and would like to apply or would like to forward it to somebody who you think would be a really good fit for the network, now's a great time to do that as we're going through this little bit of a growth spurt. And so you can always check us out at amicableddivorcenetwork.com. We also have an Instagram page and a Facebook page by the same name. And our public facing concept, so to speak, is called Divorce Amicably. That's for parties who are going through divorce. So if you see that, it is all the same joined concept. So we're not competing concepts. It's all the same thing. The network is for the professionals and Divorce Amicably is for the public. So enough about all of that. I am now going to turn it over to Max. She also serves as our legal chair for the Amicable Divorce Network, which means she's on our board and is in charge of assisting with smoothing out our legal process, which is an out-of-court process to get people divorced in an informed, educated, and professional manner without utilizing the court system. And so Max is an asset in helping us with all the different forms that we do in the process and getting things running smoothly. So I really appreciate that. And so what I'm going to do is I'm going to turn over the meeting to her to talk to us about flat fees. Max?
All right, let me go ahead and share my screen. And when I share my screen, I can't see how to put it in slideshow. So let me get that set up and then hopefully I'll be able to say it. Okay, great. So we're talking about flat fees, and I know so many attorneys, and especially family law attorneys, are hesitant to try flat fees. So amicable cases are really one of your best opportunities to experiment with that. And in this case, when I'm saying amicable, I'm really talking about pre-filing settlements, which is what the Amicable Divorce Network does. And then all cases are filed with the court as uncontested. So we'll get into specifics later about why those cases are good for this. But I think if you're looking to try out flat fees and you're hesitant, you don't want to shift your entire practice to flat fees immediately, amicable cases are a great place to start. Okay, so flat fees are good for your client. Hopefully you know this, and it's part of the reason that you're here. But first of all, clients can plan for their fees. If you have any financing options or payment plans, they can use those. The financing options and payment plans that I use, I get paid completely upfront, and then the financing company takes all the risk. You can't do that, obviously, if there's an unknown hourly amount that is going to be charged. Your clients avoid the risk of having you withdraw halfway through the case. I know that's one of the worst positions for a client to be in. And they're like, okay, my attorney has gotten me all the way through this, the initial stuff and maybe through some discovery and mediation, but now we have to go to trial and I can't afford it. And they're stuck without an attorney. Flat fees also offer an opportunity for your clients to make better strategy decisions. When I was hourly, I would have clients say, oh, I don't want to do that because it's going to be too expensive. And when you couldn't give them an exact dollar amount of how much it was going to cost, yeah, it might have been too expensive. So if you're doing it flat fee, whether it's all inclusive or a la carte, they can make decisions about which strategies they want to take, taking the price into account. Flat fees do create more trusting relationships between the attorney and client. A lot of times the client is more willing to talk to you because they know you're not charging for every single phone call or every single email. So they share important things with you about the case. I don't know if any of you have had this happen. I've had it happen in hourly cases where a client does something and it's terrible for their case. And you ask them, well, why did you do that? Why didn't you talk to me first? And they say, I didn't want to pay. So that's not good. So we want to be able to build that trust, that mutual relationship. And part of building that trust is that when you're charging a flat fee, the client feels that your goals and their goals are aligned. There is a suspicion of hourly billing. Attorneys do not have a great reputation, and clients sometimes feel that attorneys are just dragging out the case and increasing the work just to increase their fees. Now, it may be work that's very necessary for the case. I don't really think most attorneys do that on purpose, but that's the client perception of it. And because of all these factors, clients end up having an overall higher satisfaction rate, not only with you and your office, but also with their experience going through the divorce process. So flat fees are also good for you. So this is a win-win situation. I have never met an attorney who loves tracking time. If you are the one attorney in the world who does, I guess congratulations to you and keep doing hourly. But it saves you a lot of time there. It saves administrative time with billing and not having any accounts receivable. I send out 1 to 2 bills per case. I'd be sending out bills monthly in every case if I was still hourly. Also with flat fees, you can make sure that you get paid in full. We talked about withdrawal from the client's perspective, but I also think it sucks from the attorney perspective. I hate having to withdraw from a case, and I feel like I'm leaving the client stranded, but I do need to get paid for my work, so sometimes I have to withdraw. Additionally, a lot of studies have shown that you lose huge amounts of billable time when you're tracking time. So you don't risk losing that billable work and actually not getting paid for it. When you set a flat fee up front, you're going to get paid for all the work that you're doing. When you're using flat fees, you can actually create a lot of efficiencies in your systems. So whether it's internal systems for your processes or technology that makes the work faster, a lot of lawyers don't use these and they're not incentivized to use them when they're in an hourly system, because if you do your work faster, you're actually getting paid less. So one of the huge benefits of flat fees is that you can do the same result amount of work and the same quality of work, but when you're using systems and technology properly, you can make that a lot more efficient. So you're actually getting paid more, but you're delivering the same product to the client. And again, this goes to better attorney-client relationships. I mentioned clients are more willing to talk to you, to tell you what's going on with their case. They feel that your goals are aligned with theirs, and that just makes them more trusting of you. If you have a client who's happier to be working with you because you're charging them a flat fee, that's going to help you have a better relationship throughout the whole divorce process. So they're great for you. They're great for your clients. And then we're going to move on from that because I'm assuming most of you think that flat fees are good or you wouldn't be here. All right. So the concern that I always hear is flat fees are impossible. You just can't do them in litigation. And trust me, I used to have the same perspective as you did. I was working with a business coach. She is the person who got me to transition to flat fees, but I told her for years, it can't be done. You can't do it in litigation. It's not possible. It's too hard. Well, now I've been doing flat fees for several years, and I know that it is possible. And we also have some great examples of other family law attorneys. These are all family law attorneys, so it's not any other areas of practice, who are doing flat fees. So it definitely is possible. I think a lot of you know Regina Edwards. I also saw that she is on the call. I'm not sure why, because she's been doing flat fees a lot longer than me, and I don't know what I could teach her. But she does flat fees here in Georgia. And I know her structure is charging for everything in the case up to trial, and then charging for trial separately. So it's a version of Allinclusive. Rebecca Ritchie is out in California. She uses an a la carte system, and she has a menu that she prints out for her clients, and they work through it together and say, okay, these are the exact services that I need. And she does not represent them throughout the entire case. California law has more clearly defined limited scope representation than we do. So it really allows her to, she can go to a hearing and say, I'm only here on child custody issues, and the client handles the rest of the hearing, and she hasn't prepped for that or anything. Gabriel Chung is in Massachusetts, and he actually has a flat fee calculator on his website. So if you want to go check that out, you can get a sense of how his pricing works. He charges clients every 4 months. So it's a subscription type service. But if you're kind of looking for a reference point of what factors to consider in your flat fees, his calculator will show you some of the factors that they consider for setting their flat fees. Lee Rosen also has a flat fee calculator on his website, and he is considered one of the pioneers in flat fees. He does them in North Carolina. And again, North Carolina is structured a little bit differently than we are. I believe they break up each issue in the case. So they have a hearing on child support, a hearing on custody, a hearing on division of assets and debts, and he charges a flat fee for each of those stages. Mark Chin is in Mississippi. I am not as familiar with the exact structure of his flat fees, but he did write a book that I have a link to later in the presentation about flat fees that I think is a great resource. And he's just another example of a family law attorney who is successfully doing flat fees. So hopefully with these 5 examples, as well as myself, you are convinced that flat fees are in fact possible. So what you want to do when you're thinking about introducing flat fees into your process is start asking how. We all get hung up on the question of whether we can even do flat fees at all, and that really inhibits your creative thinking. So if you accept the premise that flat fees are possible in family law, which I just showed you the evidence for, then you can start thinking creatively, okay, how can I structure flat fees so that they will work specifically for my firm? Because they're not going to work exactly the same in every single firm. So you're going to want to do things slightly differently than other attorneys are doing. And as we just went through those 5 examples, there were several different structures of flat fees in there. So it just depends on the models that you use in your firm, the type of clients that you serve, and how you want to set up your flat fees. All right, so we already talked about some of these structures, but I want to go a little bit more in depth with them. All-inclusive flat fees, this is where you charge one fee for the entire case, and that generally includes through trial. This is my least favorite structure for flat fees because it is A, the hardest to quote, and B, it doesn't offer any financial incentive to your client to settle the case. Sure, there are incentives in having more control over the result or in getting the case resolved earlier, but I think having that financial incentive for trial is also important to have. So I'm not a huge fan of the all-inclusive, but it is an option out there if you want to structure it that way. A la carte fees are where you're breaking it down by service that you provide. And you can break it down as small or as big as you need to. So you could say all written discovery, issuing and responding is one flat fee, or you could say responding to a notice to produce is X, responding to interrogatories is Y, issuing interrogatories is Z. You can break it down as much as you want to. I know in Rebecca Ritchie's practice, she actually has all questions screened by her staff. And if they require an attorney response, the staff tells the client, hey, do you want an attorney to respond to this? It's going to be X number of dollars for the attorney to respond to this email. So she really breaks it down into the nitty gritty. I think that's a little intense. It's a lot of management on your end, but really you can make those a la carte pieces as small or as big as you want them to. Case stage is breaking down litigation into stages. And yes, I know that things don't always happen in the exact order, but based on your experience with cases, you know how most cases are likely to go. This is essentially the model I use, and I'm going to show you my case packages on the next slide. But this is, for example, breaking it into pre-filing negotiations, maybe going through mediation, going through the close of discovery, and adding on a temporary hearing as a separate stage, because not everyone uses a temporary hearing. But you can break it down for whatever stages make sense in the way that you want to structure it. And then final trial would obviously be the final stage. In a subscription plan, you can set any length of time and you just have the client pay periodically for as long as the case goes on. So you could do 1 month, you could do quarterly, you could do 4 months. That's what Gabrielle Chung does. I think 4 months is a long time. I will tell you that I have tried subscription fees, and for my practice, they were a total failure. So that is, I guess, next to Allinclusive, my least and favorite method of setting up your flat fees. I think you have to do a lot of client management when you're doing subscription fees in terms of managing expectations of, hey, this is how long your case is going to take. And yes, you're going to have to pay again at this point, and just constantly reminding them of that, because they seem to get to the next payment and they're surprised that they have to make it. Making a shorter window for payments would make that easier. So if you did a subscription monthly or had them pay every 2 weeks, so you can make it a monthly fee, but divide it on the 1st and 15th. The more frequently someone pays, the more used to paying they are. And finally, you can do a base rate plus add-ons. So your base rate, you'd probably want to include all the things that are going to be harder to track. So all client communications, emails, calls, all negotiations with opposing counsel, and then just add on significant things. So that might be discovery, that might be mediation, and have an a la carte price for those. But you want to include most of the stuff in your base rate so that you're not doing a ton of tracking and a ton of separate billing. I am sure there are different ways out there that you can structure your case fees that I have not encountered or thought of yet. So you can really get creative as you want. These are just the models that I see being used and being discussed. Okay, so I just wanted to give you an example. These are my flat fee case packages. As you can see, 3 of them are for uncontested cases for different levels of negotiation. I really focus on amicable cases. So even for clients who don't go through the Amicable Divorce Network, most of my cases are resolved before filing and filed as an uncontested. And then we have 1 contested package. So I actually go over this handout with clients in our initial meeting. And I talk about this is which package I think is the best place for your case to start. And this is the highest that I think you're likely to end up. And then I give them a specific price for their case from the lowest package that I recommend for them. And I always recommend starting with the lowest cost package possible, so we can save them money if possible. And then I quote up through the litigation package. So they know if it goes up to that, what it's going to cost. I do have a note on here, as you can see, that contested court appearances are not included in that litigation package. So that's kind of a hybrid where I do a base rate plus adding on certain a la carte items. I have tweaked this model a lot. I previously used to present it as case status, and I was doing more contested cases back then. So I presented it as through mediation, through discovery, temporary hearing being its own stage, and then a final trial stage. And that really overwhelmed clients, and they freaked out and they thought that the case was going to be too expensive. This is essentially the same style. It is case stages. It's just, okay, do we have an agreement that we're just going to draft up and process through the courts? Do we need to get involved? Attorneys need to start negotiating, and do we actually need to go to mediation? So those are stages. They're just more broken down pre-filing stages, because that's what I focus on now. Before I really switched the focus of my practice to low conflict cases, I did have it broken down along more traditional litigation stages. And clients just digest this a lot more easily. I think they're used to seeing software with different packages of services. And so they digest this case package presentation much more easily than they digest the case stage presentation. So that's another thing to keep in mind when you're presenting your fees to clients. You want it to be in a way that makes sense and is appealing to them. Okay, so the question on everyone's mind is what if my case explodes? That's what we're all always worried about. And yes, it is a risk, but you have to draw the parameters of what your flat fee representation includes. And I know you can do that because you draft contracts for your clients all the time. You probably have an existing engagement agreement that you drafted. And so this is just drafting a different engagement agreement that allows for those contingencies and what is and is not included in your flat fee packages. If you are not a member of the Amicable Divorce Network yet, I highly recommend that you become a member. I know we do have a wait list in some counties in Georgia, but there are some counties that still have spots available, and you can get on the wait list if your preferred county is full. But Amicable Divorce Network, I know Tracy covered this a little bit. It's an out-of-court process. So all the cases are settled pre-filing and then filed as an uncontested. So if you're using that as a way to test flat fees, you have a very clear delineation of I'm not doing any work after a contested case is filed. If we file as an uncontested, obviously I'm going to guide it through the courts. But if the other party goes out and files a contested case, then you can switch over to hourly if you're not comfortable continuing to do it on a flat fee basis. There's a specific process and timeline. Everyone agrees to follow it. So both the attorneys and the clients agree, this is how we're going to handle this case. And it really mitigates your risk because it's pre-filing. You're not going to have formal discovery. You're not going to have temporary hearings. There are going to be a lot of things that just aren't a possibility in the case. And you've agreed, okay, we're going to do this on this time frame. This is when we're going to exchange voluntary discovery. This is when we're going to mediate. There's a clear flow of the process. Plus the cases are lower conflict generally. They're lower conflict, A, because you have two parties who've agreed, okay, I think we can go through this Amicable Divorce Network out of court process. Super high conflict parties probably aren't going to agree to that. And you also have an opposing counsel who's part of the network and is like, yeah, we're going to try and resolve this amicably and not blow stuff up. So you know you're not going to get shenanigans from opposing counsel. If you cannot become a member of the network yet because your county is full, you can still use amicable cases, just not the official Amicable Divorce Network process, to test out flat fees. So you can still say, okay, all pre-filing negotiations are going to be on a certain flat fee. And then if we can get the case filed as an uncontested, great, the flat fee covers that. If we can't resolve things in pre-filing negotiations and a contested case is filed, you can switch over to an hourly rate if you want. So you do want to think about what you're going to exclude and include in your flat fee package. These are just some ideas. You're going to want to think about what your typical clients are like and what is likely to be pain points that could drive up the work on the case that you don't really want included in your flat fee. So I have a provision in my engagement agreement about excessive evidence review. So that is really for text messages and recordings. It says that the client's going to point us to the juicy stuff in that so that we're not unnecessarily watching hours and hours of recordings or reviewing 3 years of text messages when a lot of times there's not very good content in there. Now, sometimes I'll give things a cursory review and you can tell, hey, look, this is a lot of fighting back and forth. I know your ex has said some horrible things, but you've also said some horrible things. So maybe we don't want to use this at all. And you don't need to point me to the juicy bits, but I'm very clear. If it's, if my initial evaluation, unless you tell me that there's some huge other section where the evidence gets really good, if my initial evaluation is it's not going to help us, then I don't need to keep going through that, which you wouldn't do on an hourly fee because you wouldn't want to waste your client's funds. I also don't accept hard copy evidence. This isn't really an issue for me because I work remotely and my clients have never really tried to present hard copy evidence, but that's just something that you might want to think about if your client is going to bring by 5 years of bank statements in hard copy and you need to organize and scan them all or outsource that. You want to either know, is it or is it not included in your flat fee? Because that's something that could be a lot of administrative work for your staff. I do not include depositions in my flat fees. Those are an a la carte option. That's A, because depositions are not super common in family law. B, I think you usually don't get a good ROI with a deposition. So I didn't want people just being like, oh yeah, take 10 depositions, really make the other side suffer, when we're not actually getting something good out of it. So yeah, we can do depositions. It's just going to be an additional fee. I recommend you set some parameters for communication, but I recommend you not be too strict about this. You don't want to create a situation where you are doing more administrative work tracking these things than you would have been doing just billing your time. So my provision on communications is something pretty general about like, it has to be productive communication, and our team is going to redirect you if we feel that the communication is not productive. I do require clients to make appointments. I don't take unscheduled calls, but they have a link where they can book directly on my calendar. So it's pretty easy for them to do that. But that's one of the parameters that works for me. I think you eliminate a lot of the panic phone calls if people can't just call you and get you any time of any day, if they know, okay, I'm actually going to have to wait till tomorrow to have a call about this. But you don't want to be in a position where you're saying, okay, you only get X number of emails per month, because then you have to track every time that person sends you an email. And that's pretty annoying to do. Same thing for phone calls. Like, do you really want to track how many phone calls they have? Just give them the link, let them schedule. You will be able to tell if it's getting excessive, and then you can have a discussion with the client, because this is really a client management issue of, hey, we're actually going to do this a little differently going forward. You can include or exclude the following expenses. I think you just need to make a decision. Your engagement agreement probably already spells this out pretty specifically. I include the court filing fees in my flat fee because I know I'm going to have those in every case. I do not include any office admin expenses like postage. Well, I rarely mail things anyway, or copies or anything like that. I think it looks really cheap, even if you're doing hourly fees, to include those. I think you should just adjust your hourly fee accordingly so that they can be included in the fee. But yeah, I never bill anyone for those. So they're all just included in the flat fee. I do specifically exclude the fees of other professionals. And that's something I would make sure not only is in your engagement agreement, but that you have a conversation with the client about. So it is written on the quote sheet that I give every client that we don't pay third-party professionals, including mediators, because that can be one of the biggest surprises. If they haven't understood that, then you get to mediation and they're like, oh, great, it's not going to cost me anything. No, 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 you're going to have to pay the mediator. So you just want to be clear whether or not those expenses are included in your fee. I recommend that you set a length for representation. You may have noticed on my fee chart, each case package has a different number of months that it can last for. This is so you don't get stuck in endless representation. I know we've all had the case that goes on forever and ever. And you want to be in a position where you can say, hey, client, we're actually going to need another fee if it goes over this amount. You can extend this. My length of representation really goes until things are settled. So once it's settled and we file as an uncontested, I'm not counting that time to just guide it through the court process. And I often give a significant grace period on the length of representation. It's really to keep things moving along. And it's for those cases where there is some other issue in the representation. If your client's asking you to do something that you just can't possibly achieve, this gives you an out from the cases, or it gives you a point where you talk to the client and say, hey, this has gone on too long. We need to bump you up to a higher case package. For the following 3 items, I actually have a clause for each of them in my engagement agreement. This is really just to set the tone that we're not going to do a bunch of unproductive work just because it's a flat fee. We're not going to try and achieve unreasonable goals for the client. We're going to advise the client. Like, I've had clients just, want to get out of something that they've signed that you're like, there's no hope of getting out of this. Sorry, like we can't do that. That's not something that's included in the flat fee. And then duplicative work. And this is really for voluntary discovery or formal discovery if they don't get you their documents in time and it makes you do additional work. I don't really ever have to enforce these. They're just in there so you can, if things are going south a little bit, you can have a discussion with your client about, hey, we actually need to shift the direction of this a little bit. This certainly isn't everything that you need to think about whether or not you're going to exclude or include, but you definitely just want to take the time to think about, how do your cases normally go? Where are those pain points in your cases that could drive up the fee, and address it in your engagement agreement so that you and the client are on the same page. So I highly encourage you to experiment with flat fees. I will tell you, I have messed up with flat fees a lot. I told you already about the subscriptions. Those were a disaster. I stopped those almost immediately. So that was a lesson learned, but it was okay. It was still good that I played with it, and I learned that that didn't work for me, and there were better ways that I could structure my fees. So here are a couple ways that you could experiment with flat fees. And especially if you're hesitant, you don't want to just say, okay, my practice is entirely flat fee now. Great, here are some starting points. So we've talked about amicable cases, any pre-filing settlements. It's pretty easy to carve out the parameters of what a flat fee will include. You can also practice through a case stage portion. So if you say you'll represent someone through mediation for a flat fee, but then after mediation, it transitions to hourly, that also gives someone a pretty big incentive to try and work things out in mediation and reach an agreement. You could do it by the facts of the case. So low asset divorces where there aren't really assets or debts to divide. Well, sometimes low asset divorces do have just a ton of debts, but if there aren't a lot of debts and aren't a lot of assets, you may say, oh, I can do that for a flat fee because there just aren't too many facts to worry about. Same thing, you might want to start with just divorces without children because you know you're only going to be dealing with the financial issues, and custody can certainly expand a case significantly. So those are just two case types that you could start with. You can craft out any type of case that you want to start with, but these are two that might be relatively easy to try. You can also just experiment by saying, hey, I don't want to limit it to a certain case type or a certain procedural step, but I can't make every case flat fee. I'm too scared to do that. So you could say, I'm going to take a certain number per month. You know, once I get 3 flat fee cases or whatever is appropriate percentage wise to your practice for the percent that you're comfortable taking. Once I get those number of cases, everything else for the month is going to be hourly. You can also just pick something random. So you can just say, okay, every consult that I have on a Tuesday is going to get offered a flat fee. So you know when you're going into a consult on Tuesday, okay, they're getting the flat fee option, but then you still are keeping the majority of your cases hourly. So there are a ton of different ways you can play with it. I recommend that you pick, if you're not comfortable going completely flat fee, which I think everyone should go completely flat fee, but if you're not comfortable doing that yet, pick one of these or carve out something else that specifically works for your firm and start experimenting, because the only way you're going to get better at flat fees is actually trying them. Okay, so here are some resources for you all. Obviously, this is just a brief one presentation that we have. You probably want a little bit more information before diving into flat fees. So these are some that I recommend. Britta Long is a flat fee and law business coach. She has some free and low cost resources in her Facebook group, her book, and her podcast. So I really recommend joining the Facebook group and ordering her book and checking out her podcast. If you're hesitant to invest a lot of money into developing flat fees, this is a good way to get introduced. If you really want to go in and have someone help you craft flat fees for your firm, her coaching might be a good option. Mark Chin, who's one of the family lawyers we talked about earlier, who does flat fees, he wrote an ebook, Dumping the Billable Hour. It's pretty inexpensive and a super fast read, so I definitely recommend that you read that. Another book that is not law firm specific, but is for professionals generally, is Implementing Value Pricing by Ronald Baker. This is one I have not read yet. It is sitting on my coffee table in my pile of books to read, but it is a really great resource for flat fees. The next 2 resources are not flat fee specific. They are for the business of law generally, but I wanted to include them because they do have a tendency towards flat fees. Lawyers Lab is actually where I learned to do flat fees. And they have some free resources as well in their newsletter and podcast. And they also have a book. They do have a coaching program. As I said, this is not exclusive to flat fees, but if you want to set up flat fees, they are a resource that could help you. And Rosen Institute is Lee Rosen's coaching business. Lee Rosen, the North Carolina lawyer who does flat fee family law. He also has a new newsletter and podcast and also offers coaching. And he has been such a pioneer in flat fees. So even though the coaching is not exclusive to flat fees, I think you could really learn a lot there. So with that, that is all that I have for the presentation. So hopefully we have some questions and can dive in and address those.
Hey, Max, it's Regina.
Hey.
Hey, I'm going to leave my video off so y'all don't get whiplash trying to figure out the difference between the person on your screen and the person behind the camera. I just want to say I stopped doing the model where I charge all up to trial. I only do that if I'm taking over a case from somebody else and discovery is over. So I actually cribbed my current model from Tracy Rhodes, who does a lot in Cobb County.
Okay,
so she and I kind of met over lunch and sort of discussed some ideas, but it's basically kind of a schedule. They pay an initial payment, and that payment is applied to all of the things that could possibly happen in a family law case, and it just gets applied to that schedule. So like in 95% of my cases, I don't ever have to go back to the schedule because I get a pretty hefty upfront payment, usually anywhere between 20 and 40. And I only really have to go back to the schedule if it just kind of really goes out of control and say, no, your fee was eaten up because we have all this other stuff. So anyway, I just kind of wanted to say that's kind of how I have tweaked it. But I've been doing this for, oh my gosh, 15 years, and I have changed like 20 different times because I definitely did it wrong. So you have gotten it right in a way shorter amount of time than I did, because I spent like the first 10 years messing it up.
So it sounds like you kind of have like an a la carte services chart, and you get a retainer to apply to each of those services. Am I understanding that correctly?
Something like that. In reality, how it works is that I charge a flat fee that lasts through mediation, and then pretty much a flat fee for trial. That's pretty much how it operates. It only doesn't operate that way in a case where it does balloon. And then I go back and I just start applying it to the schedule and saying, you know, these are the additional payments that, like, if there's 2 or 3 temporary hearings and a whole bunch of experts and all this other stuff, I go back to the schedule, but I almost never do it because I don't need to.
Yeah. Awesome. Well, thank you for sharing that, because that's even another model that could be applied. And just for those of you keeping track, Tracy Rhodes is another Georgia family law attorney. I knew she was dipping her toe into flat fees the last time I talked to her, but that was over a year ago, I think. So I didn't realize she was fully up and running with that. So yet more proof that flat fees are totally possible in family law.
Does anybody else have any questions? I don't see any in the chat. So just if everybody wants to hang on for a second, you're absolutely welcome, but I'm going to thank Max for your presentation. Thank you very much. We're going to stop the recording, and anybody who wants to hang around and chat, please do.